phone call.
Okay, I'm going to go live, Eckert. So,
Okay.
Eckert, we're starting.
Okay.
Good morning, good afternoon, good evening, everyone, regardless of where you are. It's somewhere, it's always 5 o'clock somewhere for somebody. It's always morning, always evening. Welcome to Conversations with Rudy Rivera. Today, I am thrilled to have a very good friend, colleague I've known for many years. We've met on different continents and different parts of the world. I'm sure that's the same with some of you who are here listening, have met Eckhart at some part of the world. Eckert Broderman is the managing partner at Broderman John, a law firm, German law firm based in Hamburg. And um, Eckert is an author of a number of books, primarily on the UNIDROIT Principles of private international law. Welcome, Eckert. Eckert, just give us a 30-second bio on yourself, because I think most of the people here know who you are.
Okay. Thank you very much, Rudy, for having me in your in your talks, in your line of talks on all kind of subjects. And law is not always the most sexy one for people, but law is fantastic, and UNIDROIT principles are fantastic. I was myself trained in 3 jurisdictions, first in France for 4 years, then in Harvard, New York Bar, Washington, large law firm, and then a third time in Germany with then a doctoral thesis on jurisdictional doctrine, a long one, a book on European law and private international law. And then in 89, 35 years ago, I wrote my first book on private international law and international litigation and arbitration. It just came out in the 9th edition. And so I'm very conservative in the beginning, and then I at some point discovered these UNIDROIT principles and decided that's exactly what we need to overcome these national boundaries, which I discovered in all those 3 nations when I studied locally.
Well, Eckert, practicing in various jurisdictions like you and I have, I've mostly done litigation in many different jurisdictions, but had to deal with contracts in a number of those jurisdictions. It's always challenging to, get the right terms into a contract, terms that everybody understand. And there's been a big movement since, I don't know, a long, long time ago about standardizing contracts in international business transactions. And that's really the UNIDROIT Principles on International Law. Can you tell my audience what that is and what its purpose is?
In 1968, a long time ago, a guy at UNIDROIT, which is an international organization set up by the League of Nations in Rome, came up with the idea we have to try to bring up the different systems. At that time, the world was divided in 3 parts. Basically, you had the socialist countries, Soviet Union, Ukraine, Russia, all those parts together, and the common law countries and America, and then the continental European countries, including South America and China and Japan at the time, with civil laws based on the Central European countries. And within Europe, you had those distinctions between all the Romanistic law countries, basically all the laws of the countries which Napoleon conquered at some point, and then the German law countries and those countries like Greece who followed the German law. And so there was a lot of diversity. But the traders, the need of the traders cross borders, they are similar, and they want it simple, and they want a solution where you can understand it. I mean, why should you accept as a German the Greek law, which you can't read the Greek? Yeah, or why should Ukrainian accept New York law if they can't? I mean, or why should you accept Ukrainian law if you can't read Ukrainian? Just so it goes in all directions. So they came up with the idea we need something to join all of that. And it took them 12 years until they initially set up a working group. And that came about in the very year in which the work on the CSG stopped. That was finished in 1980 based on compromise in the 1970s. And they said, okay, now we have the CSG internationally as a treaty. Only last year we had the last accession of Saudi Arabia on some of the CSG treaties. So it takes years and ages to get hard law into work. And this is why they came up with the idea we need something soft, subtle for the merchants as default rules on which they can use as a starting point for their
But there are 65 countries who signed off on UNIDROIT, but the United Nations has endorsed the UNIDROIT principles, basically the clauses. But anybody any business person, regardless of whether the country is a signer to the treaty or acquiesced or can agree to be bound by those principles.
Yes, actually, there is the Union Internationale des Avocats, which is one of the big leading international organizations. You have the IBA, the OER, and maybe the IPBA out of Tokyo. And the Union Internationale des Avocats is the first one which said, speaking for about thousands of lawyers, millions of lawyers, because all the bars, the state bars of many dozen countries are member of the OER, and they endorsed the UNIDROIT principles and said, do it the same way as the United Nations did.
Well, but we'll get into that a little bit, but I want to have you compare UNIDROIT with the Uniform Commercial Code in the United States, the Convention on the International Sale of Goods. I understand that they're not necessarily interchangeable, right?
Yeah, there is a very nice book from Henry Gabriel, a New York professor, and he puts forward the CSG and then next to it the UCC and the UNIDROIT principles. So you always get for each point the comparison in English.
But my question is, doesn't the Convention on the International Sale of Goods, or the UCC, the Uniform Commercial Code, doesn't that solve part of the problem? What I understand from what I've read on the subject is that the CISG is deficient in the amount of damages, and therefore you would have to implement some of the UNIDROIT clauses, contract clauses.
Not really. I mean, first of all of these sets of rules you're mentioning, they admit party autonomy. So under the CSG, I looked it up since we had our little pre-discussion. Under the CSG, Article 74, etc., you are absolutely free to ask for damages if the other party doesn't say it. It says damages for breach of contract by one party consist of the sum equal to the loss, including loss of profit, suffered by the other party as a consequence of the breach. And then the number of rules that needs to be foreseeable. So basically you can do, even under the CSG, you get damages.
Well, what's been the biggest obstacle? For example, you talk to a US lawyer, you talk to a German lawyer, and they say our contract rules, our law is very sophisticated. What argument would you make to them on why you should implement the UNIDROIT principles, contract terms?
I would say make it simple. If you are happy with your law, let's say, of Texas, and you get the other party to agree to the law of Texas, you can operate with it. There's no damage in doing it. But there may be situations where the other party may not accept the law of Texas. There may be situations where the other party, or we just think it's a matter of fairness, let's do something simple, and it simplifies international transactions in terms which everybody can understand. And even if you impose your law of Texas, it is risky, because you may think you're in good shape because you take your Texas law, but comes to mind a case which we had with Las Vegas, and under Las Vegas you have a theory whereby you can always terminate a contract and then ask for, just work on the damages. This type of approach that you conclude a contract, and if you don't like it anymore, you just breach it and then pay damages within the agreed limitation of liability. That type of approach internationally doesn't work, so you end up in dispute. Even if you may be right under your local law, you still have the hurdle of the arbitration and the cost of fighting. So it's not worth it.
For example, in Texas or New York, California, there's a whole line of jurisprudence that interprets, contracts in the sense that based on litigation. Okay.
Yeah.
And what jurisprudence is there with UNIDROIT to say, well, that defines or clarifies certain terms?
So for one, the UNIDROIT principles have been worked upon and prepared by experts from around the globe. So they're really the result of very in-depth discussion on the different aspects. From America, for example, one of the big brains in there was Professor Farnsworth, who's one of the big American brains on contract law. And so you have a very good starting point, and you have terms which are readable to anybody. And by now, there's something called unilex.info, for example. That's a database where you find hundreds of even national jurisprudence. We had a test last week on Spain, and we found in the Spanish database 1,800 hits if you put in the word UNIDROIT in the database. So that's the point. In America, you have a different impression because everybody in America is fond of its own state laws. So if you put in UNIDROIT in the database in America, you don't find so much. But there is a world outside West law and outside America. And in this other world, you find hundreds of awards and national jurisprudence. And a lot of courts saying they use the UNIDROIT principles to interpret their own national law. In my book, in the annex preamble, I wrote a book on UNIDROIT principles, which is out in red and blue in different colors, and by now also in Chinese and Spanish. And in that book, I wrote an annex to the preamble where I went through, for months, all kind of judgments and always copied and cited the language saying and documenting how national laws from Jerusalem to Brazil, they all use the UNIDROIT principles to interpret their own law or to resolve conflicts in international transactions.
Well, is it similar to say in the US system, you have something called on the ambiguity of a contract. So let's say that you have a contract and you can't really decide what they meant with the contract, and you construe the contract against the person who wrote it.
Yes.
Does that also apply with the UNIDROIT principles?
Yeah, that's a contra properentum rule, and we have that in the UNIDROIT principles. And actually, the chapter 4 in interpretation is one of the strongest chapters in that contract because from a simplistic perspective, you have different origins of interpretation. In continental European countries, for example, in Asian countries, you look more into the circumstances. And in London and in New York, you look more just at the plain meaning of the rule. That's the starting point. And here it starts already with language. I mean, you speak English because you're native. I don't speak English because I speak a foreign language, and there may be moments where I just don't get the last hit. And I give you an example from only a couple of weeks ago. We had a contract to be construed under English law, and it was starting arbitration. And then I had this discussion with the colleagues in England who were taking over to do the arbitration under English law. And we discussed the strategy, and the interpretation was all about the interpretation of a contract where the other side had kind of sleeved into an indemnification clause some language where they claimed that even after the period, in the end of warranty period, they still could claim for damages. And I told them, listen, this is a rule under the UNIDROIT Principles. First, they looked at me like crazy. And I said, usually these is general principles. So please put somebody on research, find out whether you find that result. And of course, they found it. And they came up with a very nice quote here from Lord Hodge in 2015, and saying interpretation is the ascertainment of the meaning which the document would convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. That's a nice general rule, which is very akin to the UNIDROIT Principles, but you have to find it. And because I always use, I've done it several times, I'm using the UNIDROIT Principles also as a starting point to then detect in the local law what I need to find. And it goes the other way around too. If it's not in the local law, you can very often use the UNIDROIT Principles. As the Court of Jerusalem once said in 2014, it's like an opinion in literature. It has different ways to interpret the contract, and one of them is in line with the general system and the general tendency, then this is a better way.
Well, you mentioned early on, Eckert, that this is soft law. There are a number of people we have who are experts in this area, but there's some who know nothing about UNIDROIT. This is probably the first time they're listening to it. Explain what you mean by soft law in the international world.
Of course. It's all about party autonomy. In the beginning, there's freedom, and we can do contracts as we wish them to do. But when you do a contract project, there are so many things to think about. And this is why it's helpful that people sit together over a period of over 40 years. Which in 1980 they started, and in 2016 we have finished the last 4th edition. And in all that period, they worked through all the topics of a normal contract, from contract formation to validity, joint liability, all these issues. Set off. I mean, take set off. Under my German law, you cannot set off dollar versus euros because they are not of the same kind. They are different currencies. And that's something when I negotiate with somebody from another country, one of the last points which comes to my mind, shall I include a special clause, which exchange rate shall we use if there is ever a set off between dollar and euro? If you come forward with that type of topic to a in-house counsel with its minds on, or a client and a businessman with its minds on, he would say, you're crazy. Don't waste my time and my budget and my money to think about those things. This is why it's helpful to have a starting point where it's in there. And then you just can start with your own template, however you like to do it. Start with that, use it, and they just flow in. They help you. They're like a chameleon helping you.
Well, Eckert, the UNIDROIT Principles, they play a vital role in commerce because they provide an alternative choice of law in instances where parties cannot agree on specific choice of law.
Mm-hmm.
Now, in some of my dealings, for example, I think, for example, people blindly say, well, let's have the law of Germany, for example. Okay. Well, Germany is a very sophisticated legal system, but loser always pays cost. Where in the US, loser doesn't pay cost unless it's by statute or by agreement. Okay.
Yes.
So would that be a reason why somebody would use the UNIDROIT clauses of action? Because I think people have to go into what's the law of the country before decide, well, we won't want to be there. The other side says, well, we don't want to be there either. Is that the reason why people go into the UNIDROIT? I mean,
let's do it in 2 steps. Step
okay.
1 is when you do a contract, in my opinion, the most important clause is to decide if ever there is dispute, who shall decide? If the contract is fine and lived up, you put it in the corner, you never open it up again, and you just, exchange the duties. Fine. You need the contract when there is a potential misunderstanding. And then a good contract can do a lot. And if you have a good starting point, let's say a good arbitration clause, where you agree on arbitration and you can shape the arbitration within 3 months, 6 months, normal arbitration, standard clauses. If you do the arbitration, that's the most important clause. And all arbitration regimes that I know of do allow the choice of soft law like the UNIDROIT Principles. Most recently, only last year, the CETAC rules in China changed and also now admit to arbitrate under general principles of law, like the UNIDROIT Principles. I just finished a book on the CETAC arbitration rules, and it's also in there. You can also use general principles in China. So around the globe, you can use it. And that doesn't function with, let's say, a local American law. If you think New York law is easy to access, I must tell you, in many parts of the world, including my home country, it is not easy to access. Because we're not connected with West law and all that stuff here. And it's not an easy access to the computer and I get the most recent results. And it's complicated. Like in my English example, the UNIDROIT Principles, it's fast and ready to find. It's 211 rules. It's 20 pages to read. So I have a very good starting point. And regardless of UNIDROIT or CISG or UCC, there's party autonomy, so we can shape the contract. And in that regard, UNIDROIT Principles, at least for all my foreign clients, and also even for some German clients in cross-border situations, UNIDROIT Principles are better than German law because you don't have all this complexity of consumer protection. Laws by nations are written for the people who vote. So you want to make things simple and make the consumers happy. And when you do business among merchants, you don't need consumers happy because they're not part of the deal. It is important to have consumer protection and all that stuff, product liability. But all that stuff is not needed when you do a business-to-business transaction. And for that, keep it simple and keep away all the stuff which is consumer-related. And let's focus on the business. Makes it more simple.
Well, I was looking at some of the principles, okay, and I read through your book prior. I noticed there are a lot of similarities between that and with the terms of contract law that we have. So, for example, I see good faith in dealing. That's a contract law, right? You enter into a contract under UNIDROIT principles, you have to act in good faith, right? You can also be in breach under UNIDROIT. It seems to me, from what I've read, it seems to follow a lot of the US principles. Is there ever a situation where the principles are inconsistent? In other words, where you draft a clause and the country says, no, it's not. For example, I know with the international sale of goods, for example, somebody in Colorado signs a distributorship agreement with somebody in the UK. Well, and the exclusive law is US and the place of arbitration is US. From what I recall, that clause is voidable because basically the law in the UK, as I understood it, says you can't, if you're going to have a distributor, it's got to be litigated where the distributor is if there's a dispute. Do you ever have those situations come up where a court says, nah, that law, that contract is invalid because it violates our state law?
Now we go to the heart of private international law. And we say we have to qualify, to classify, to distinguish. And the question is where you can arbitrate or where you can bring something to court. That's international litigation. Has nothing to do with the UNIDROIT Principles in the first stage. Once you are in an arbitration or in front of a judge, and you have to look at the UNIDROIT Principles because it's agreed, people wanted it, then you look at it and take it from there. And the UNIDROIT Principles are a compromise of all these different legal regimes. So in the subtle details, you may find here and there a deviation, but generally speaking, it's exactly the experience you make. You start looking at the UNIDROIT Principles and you recognize a lot which is very familiar. I did the same with, let's say, German law. I made for the Germans in a German version. I took the 211 rules And for 100, I think 30 or so, I could place a German paragraph of the German statute next to it and say that's the same thing. And when I have students from other nations, regardless from where in the world, I very often give them the work. Here's the UNIDROIT principles. Compare them with your home jurisdiction and give us a little speech, as a continued legal education at the office. And each time they come up with the same kind of result because it's such an ingenious compromise. Basically, what they did is to take the UCC and to internationalize it. I mean, the genius of the Americans was that they took English law, and then when they wrote the UCC, they added good faith and fair dealing to English law, because in pure English law, Commonwealth law, you don't have a general principle of good faith and fair dealing. That's the Americans who invented that. By the way, with Leveland, a guy who also studied and taught at some point in Germany. So, inspired maybe possibly there, he wrote this, and they jointly wrote it, and America made good faith and fair dealing great. And that principle is now internationalized. The UCC is internationalized with an international restatement, and this is the UNIDROIT principles. And this is why it comes in so helpful if you do cross-border business.
Well, and relying on the UCC, the Chinese version of the UCC, I mean, the terms have the same name, but they're always different. Like the perfect tender rule in the US is different than the perfect tender rule in China, and seasonal acceptance or rejection is different in different jurisdictions. Ecker, we have a question. Is it common for UNIDROIT principles to be applied in international e-commerce transactions?
I don't know whether it's common. I think it's nowhere common yet because they were finished in 2016, and I don't think that so many people have already taken the time, like our audience today, to look into them and to study them. But it's like the invention of the smartphone. Prior to the smartphone, we used cable phones or pay phones. Yeah, I still remember those booths. You had to stand on the booth to get in and to speak. And that is all the national laws. And now suddenly we have the smartphone of the contract law, and that's the UNIDROIT principles. So, and you make your own choice. Do you want to go on and going to the phone booth and standing out there in the rain until you find you can open the door and enter? Or do you prefer to work in a modern way?
Well, I think sometimes with all the hacking that's going on, I'd prefer a fax machine. So they don't steal my stuff, Eckert, tell us about what are probably, in your view, some of the most important clauses, some of the most important things that the UNIDROIT principles brought to international transaction. I mean, we know one of them is continuity, I guess, having, common language for contract terms throughout the world, but what are some of the others?
I mean, the starting point is the principle of good faith and fair dealing, Article 1.7. And then throughout the 211 rules, you have more specific rules, because of course we had on the team also English lawyers. And maybe I didn't mention so far, but I've spent some years on the team preparing for the 2010 edition. For some 5 or 6 years, I was part of the team observing the core team working on the UNIDROIT principles. As an observer from practice on behalf of the International Bar Association Outer Space Law Committee. Because in space law, that's where I started. In 2001, I discovered the UNIDROIT principles in an arbitration in Switzerland. I fought for English law, the other side fought for Swiss law. We both pretended to want neutral law. None of the two were really neutral, and the wise arbitrator proposed to agree during the arbitration on the UNIDROIT principles as real neutral law. And we all agreed on it, because in the end, we were fighting for damage. And you always get damage if there's a reason to get damage, but you don't get it unlimited. And whether you call the damage in the end, in the English test, is it too remote? Or if you, Harvey versus Baxtendale, 1854, or whether you call it in the German way, is it adequate? Or whether you call it the French way, is it foreseeable? It doesn't matter that much. So the formulations they found in the UNIDROIT Principles is something we could live with. And so both parties, and I've seen that several times happen, agreed during the arbitration to fight under the UNIDROIT Principles. We did it once in a Chinese case to avoid the cost of proving Chinese law to arbitrators sitting here in Germany. So I come back to the English, and the English, they don't like good faith and fair dealing. It's so move for them. It's too soft for them. So this is why the English said, we need to do something which is specific. Certainty trumps equity. Sorry. I had this off, I apologize. Ausmachen. And so we did, so in order to cover, I apologize for that. In order to cope with the need for certainty, we went, and the working group went through all the steps of a contract life, and then agreed on a rule which, on the one hand, is specific enough for the English lawyers, and on the other hand, still in line with good faith and fair dealing.
Eckert, but you said something that, it's related to a question I asked you earlier. You both wanted a neutral law, basically. Yes. And so goes back to my original question. So people don't want to be in under one country's law or another, and somehow they feel that the UNIDROIT law, clauses are neutral.
Yes, they are. They really are.
Well, explain to me how they're neutral, because you have contract terms that mean certain things in each country, right? How is it they're neutral?
Because let's start by, let's say, making a contract. And if you speak with merchants, everybody understands that you need an offer to know, with some specifics in there, to understand what is being offered. And to come to a meeting of minds, you need to accept that offer. So there's an offer, there's communication of the offer, and there's acceptance. That's the starting point. So people could agree on that. So that's a neutral way, because it's holistic, it's universal.
See, to me, neutral means that I might be afraid of how German law would interpret certain contract provisions versus US law would interpret certain contract provisions. And therefore, I want something that everybody understands.
In the beginning, you write the contract, and when you write the contract under UNIDROIT, you write it under under Chapter 4, and under Chapter 4, you have a general rule on interpretation in, I think, Article 4.3 and 4.1. A contract shall be interpreted according to the common intention of the parties. So if we are clear what we mean, we can write that down. If such an intention cannot be established, that's a matter of procedure and what comes out in the arbitration. The contract shall be interpreted according to the meaning that reasonable persons of the same kind as the parties would give to the same in the same circumstances. So that's very objective, and for that you have a series of factors which are helpful to look into it and to interpret what the parties meant. So yeah.
Okay, you have a fan, okay? Because somebody wants to know, where can we buy Eckert's book? Can we get them on Amazon? And this is a person from Mexico who's asking this, and your book is about ready to be printed into Spanish. Is that correct?
In the Spanish, it's out, Tirant l'eau blanche. It's a Spanish publisher, so it's printed in, I think, 6 or 7 South American and Middle American countries. So you should be able to find it with Tirant l'eau blanche. And in English, you find it on Amazon. You find it, it exists in this blue version for the German-speaking countries. It exists in a red version from Wolters Kluwer for the international countries. Because I told the Germans, you're not able to sell books abroad. And I told the Americans, Wolters Kluwer, you're not able to sell books in Germany, which is the truth.
Well, why different colors?
So everybody's happy. One has the blue book, and the other one is the same book, and the other one has the red book. And they can do their own marketing. That has to do with IP rights and everything.
Well, Eckert, taking a devil's advocate position, I want you to take a devil's advocate position, okay? And what have been some of the criticisms you've heard about the UNIDROIT principles?
Most criticism I heard from people who never took the time to even invest 10 minutes or 1 hour into them. So this is criticism I can't take too serious. Yeah, I mean, people can go on in their old phone booths as long as they want. I open up to them when they come and ask, and then I help them. And then they can do, I mean, if you imagine you have a group of companies with affiliates in different countries, it just simplifies your life if you have one set and you can use the same license agreement with India and with China. And you only have to look at local law if there's mandatory law, because of course, in addition to the contract law, you always have to look, yeah, is there some mandatory law like sanctions, which are up to date these times, or customs? That's things you have to look on top, which is not covered by the statute.
But no matter how ridiculous, what have been some of the criticism? Because I know exactly what you're saying. I've tried to sell title insurance in different countries, and it was amazing to me how lawyers would opine on something that they knew nothing about.
Correct.
But what were some of the criticisms that you've received early on about the UNIDROIT principles?
Yeah, there's, for example, the chapter on hardship.
Pardon?
And the chapter on hardship is section 6.2. And we all went through COVID. So we all saw situations where the contract didn't work anybody. Nobody had foreseen that situation of a COVID pandemic of that kind. And then during that same time, we and try to write a force majeure letter, for example, under English law, it's not that easy. Yeah, because there is no force majeure unless it's in the contract, same in New York. Yeah, I had to do that on occasion, and I did it. I once had to write a force majeure letter from an English company to a, I think, Luxembourg company, and I played then with the ego of the lawyers because I just worded it in such a way as if I were to apply Luxembourg law, and the other side jumped on it, and so we incidentally agreed on Luxembourg law instead of English law. They had their home law, felt happier because they had the home law, but in reality, from a bird's eye perspective, they would have been better off with English law, but they accepted my choice to use Luxembourg law. So with all that said, it's good to have something which, when you look at the crystal ball for the future of a long-term contract, and there can be price adaptations. If we have huge customs suddenly coming in, the Incoterms becomes important to decide who bears the risk of additional custom. If it's a long-term contract and during the long-term relationship, more custom is coming up. So with that in mind, I had to negotiate a number of long-term contracts during COVID. How do you negotiate a contract for 15 years of automotive production when you don't know whether COVID will come back? On the other hand, it's not unknown anymore. You can foresee it might happen again. So what I did, I took the language from the UNIDROIT principles and I put it on the screen and say, okay, let's take that as a starting point and discuss. Do we want it only if it's foreseeable? Where do we want to adapt things? Is that the starting point, or do we also want to be able to adapt if COVID measures happen again and offices are being closed down? Do we want that? Who shall bear that risk? And then we had good conversations among the parties, and then we agreed, okay, it's a shared risk. And then in the consequence, if we need adaptation of the contract, who shall decide? Do you want an arbitrator to be able to decide? That's the default proposition of the UNIDROIT principles. Or do you want it otherwise? UNIDROIT principles always come along with Article 1.5, which is party autonomy, freedom to change. So on occasion, we changed it. On occasion, we didn't change it. It all depended on the circumstances of the contract.
We have another question, Eckert. Do law schools in the respective countries teach UNIDROIT principles in detail?
In some they do, in some they don't. my friend in Guatemala, Pedro Mendoza, who was one of the leading of the translating teams for the Spanish version, when he teaches normal Guatemalan contract law, a normal class on contract law, he always teaches the UNIDROIT principles in parallel to show the students the benchmark, where the law of Guatemala is in relationship to the international benchmark, and where you can use the UNIDROIT principles to fill in and to step in gaps in their own law. And I've heard that from a number of countries. I was last year in Yerevan, for example, same thing. And in other jurisdictions, they teach it rarely. I mean, in my university, I'm a professor at the University of Hamburg, and people who take my class end up knowing something about the UNIDROIT principles. Students who decide on other classes don't hear it.
It seems to me, Eckert, that one of the great advantages I see to the UNIDROIT principles is in the area of arbitration. Because, for example, what I've seen with arbitration is that most people say, let's just do arbitration. But then you have to always prove up the law. You have to prove up the law in that country to the arbitrator, right? Where with the UNIDROIT principles, it simplifies it, right? The decision of the arbitrator.
Absolutely, it reduces cost. And again, the starting point in some jurisdictions of the world, like in America, you have to prove the foreign law. In other parts of the world, the arbitrator is expected to know the law. So you are Novit Korea, the law that the judge is supposed to know the law. Of course, the international way of arbitrating is a merger. If you have somebody from a country who thinks he knows the law, he should better speak it out and give the parties an opportunity to discuss it, to discuss the law and for the right to be heard. So we have an interim, an amalgam of different cultures. But to avoid all of that discussion, if you take something which is universal, you avoid cost, time, and get it simple.
And have you seen difficulties in, say, a dispute that doesn't involve arbitration, but they've used the UNIDROIT principles, where there's been some difficulty in the foreign courts with these principles?
I have personally not done any litigation under the UNIDROIT principles in the national court. Has never happened to me. But what I do know is that courts have used the UNIDROIT principles to supplement their own law. For example, last fall, I was an expert in a litigation in Valencia. And what had happened, some Baltic firm from Estonia had sold fuel to Italian charterer of a Chinese vessel, and the fuel was taken on in Malta and in Sri Lanka. The fuel wasn't paid, the Italian charterer went bankrupt, and the vessel was arrested in Valencia. And now the question came up, is the vessel owner in charge of the liability under the convention? Because the CISG applied. And in that context came up the question, the CISG doesn't say anything on solidary liability. Is it possible to rely on the UNIDROIT principles to supplement the CISG? And if you don't mind, I would like to mention something which I read 2 or 3 years. Yeah, may I?
Go ahead. Yeah, yes.
I discovered, just read again through this famous tripartite legal guide, which not everybody may know. And I saw it when I wrote the book, but I really embraced it only over Christmas this year. And what it is a joint paper, about 106 pages long, of the on uniform instruments in the area of international commercial contracts. It's jointly drafted and released by UNCITRAL, the maker of the CISG, by UNIDROIT, the maker of the UNIDROIT Principles, and by the Hague Conference, which is the other big entity doing international privatization of laws, in particular in the area of private international law. Those three organizations joined forces and wrote out this fantastic guide. And in that guide, they came up with language which essentially says, and it's exactly, I think, at number 132, whether and to what extent external principles may play a role in filling gaps in the CSG, in the absence of an agreement of the parties, is an open issue. In the case of the relationship between the CSG and the UNIDROIT Principles, the common understanding is that the UNIDROIT Principles are not, as such, considered to be the general principles of the CSG, but rather as being able to serve to corroborate the existence of a given general principle, and thus they can be a tool to interpret the CSG or to fill its gaps. And what I did, I went through the CSG and looked for general principles under the UNIDROIT Principles, like the general principle of cooperation. Yeah, somewhere in the CSG, you have an obligation to inform the other side under certain circumstances. It's a sign, an indication for an existing general principle of cooperation. And with that, it goes on a little bit in this guide. Basically, you can use them together if you wish to use them together for contract of sales.
Well, that's what I mentioned earlier, Eckert, that the Convention on the International Sale of Goods is not complete necessarily, and it sometimes needs the UNIDROIT Principles to fill in those gaps.
Yes, they are very helpful.
And I think the biggest gap is in the area of damages.
And yes and no. In my personal opinion, I think even under CSG, you can get a lot of damages of lost profits and everything. But it helps, and you can combine it, and we have now the official documented authorization by the three international organizations to use the UNIDROIT Principles to supplement the CSG. But more important, not more important, but equally important, is the fact that you have many contracts which by their shape go beyond what is a mere simple sale of goods. You have connections, agency, distributorship agreements combined with sales of goods. You have joint venture agreements, you have M&A agreements, you have license agreements, you have all kinds of agreements on humanitarian help to Ukraine. Whatever you want to do, you can use the UNIDROIT Principles without looking at the restrictions of the CSG. This is why I personally tend to be a fan of the UNIDROIT Principles, but I absolutely honor if you go for the CSG, there are circumstances where it's very wise to use them.
I would say you're more than a fan. I think you're a preacher. You're like an evangelist of the UNIDROIT Principles. We have another question, and that is, are you aware where the USMCA, that's United States, Mexico, Canada Agreement, expressly recognizes the UNIDROIT Principles?
I'm not aware of that, but I am aware of the Inter-American Convention, which explicitly allows the choice of the UNIDROIT Principles.
And Eckert, we're getting close to the end of our presentation. I mean, we could talk the whole day about this, and we didn't even get into, some of the more important clauses of the UNIDROIT, principles. I want to leave my audience with several takeaways.
Okay.
And give me 3 takeaways that they can take with them. I mean, some who know everything, some who know more than you and me together, and some who don't know anything. So put it somewhere in between.
First of all, I would like to quote a friend, Timothy Nelson from New York, who wrote a book review of my book. And he started out with the question, why after all do I have to concentrate on it if I have a beautiful New York law, the law of Delaware, once in a while English law, why do I need to concentrate? And the answer he gives, it's like the Mount Everest, they are there. By the mere fact that they are there, if you don't concentrate on them, they may come over you and you're not prepared. So better know it to be state of the art. In practical terms, they simplify your lives because they simplify international transactions in terms which are understandable around the globe, despite all the language barriers which we're having. And everybody knows where they're coming from, so it's a good starting point of default rules. And you're free to adapt them if you so wish, and you can write your contract in the direction in which you wish things. So what is the firm policy on certain points? You just integrate it into it. And compared to German law, they are better than German law because you don't have to think about the meticulous law of standard terms in Germany. So in the end, all that reduces risk and cost because if there is less dispute about the interpretation of clauses, because you come more easily to terms, and I've had disputes under contracts written under UNIDROIT principles, and we've always come to terms. So simplification, simplified legal contracting, reducing risk and cost.
Do you think that people within the United States not involved in an international transaction, California and New York merchants making an agreement, do you think they should use the UNIDROIT principles?
I've seen them used for interstate contracts and functions well.
You have. You've seen them used
Yes.
between the states,
Yes.
transactions between the
And,
states.
you know, very often we are in a global world, if we want it or not. And especially if the two American companies themselves also have affiliates in other countries, like Asia or Europe or wherever, or South America. So the moment you have companies which are a little bit cross-border, then it just simplifies the life for everybody.
I've never heard, you're the only one I've ever heard of who says it should be used within domestic transactions and within the United States.
It's your freedom. You don't have to, you know, I'm not addicted to it.
No. I mean, I'm just saying that it's a good idea to use it.
Yeah.
I think honestly, it's a harder sell to people within the United States, where they're each comfortable with their own law, I guess, but it's an
fine.
easier
I mean,
sell for
yeah.
international.
Let people be happy. I mean, in the end, we are in charge of our own lives. Yeah. And, you know, I don't press for them. I just say they're there and decide when to use it. If you have a global company sitting in America and acting worldwide, and another one, if you have the same kind of companies, then it makes a lot of sense.
Well, people are suspicious, you know. I think when you start pushing something hard, like you're an evangelist on the UNIDROIT.
No, I mean, since 9 editions, I'm an author of a book on private international law in Germany. Basically, that's my way coming from. I come from the national laws. It took me over 10 years to find this, but it just makes sense. This is why I open up to it.
And I have to say, Eckert, I do agree with you. It does make sense, considering all the experience I've had litigating in foreign countries, you know, seeing what happens when a bad contract is written, or people thinking, gee, I never thought of that. I could see where the UNIDROIT would have been very helpful. I will take an opportunity to ask anybody who may have any final questions of Eckert before we sign off. And Eckert, your firm is in Hamburg, based in Hamburg.
In
How many
Hamburg,
lawyers
Germany.
are in your firm?
Yeah, and I declined partnership in large law and grew up this firm from 1 lawyer to now 26. And it's a lot of fun, and we only do cross-border. We focus on cross-border, and that I do since day one.
Well, thank you so much, Eckert. To me, this was really interesting, and obviously it was interesting to our audience because most of the people stayed on, and that's a telltale sign that they were interested. Thank you so much, and everyone, thank you for listening to Eckert. He's one of the smartest people I know. And Eckert, I'm sure I will see you in Atlanta or some other part of the world at some point or another.
Thank you so much. I just see we even had attendance from Hong Kong.
Yeah, we do. We have attendance from Hong Kong. So to my LinkedIn audience, thank you very much. And to my Zoom audience, thank you. Goodbye. And we truly appreciate you being here. We got donkey, we got excellent. What are some of the messages, chats? Laura Gamble said, excellent. Thank you, thank you. Arwa, wonderful. Sergio, excellent. Corinne, merci beaucoup. So.
Nice. Thank you very much. Can you take a picture? We'll stay on for a moment. If I ask here my young friend to make a picture. Wissen Sie, wie es geht? So, kommen Sie ran?
Sure, Soon Jenny, thank you, very insightful.
Can you once look to me?
No.
Okay, for the picture
I'm
here.
reading the comments. Very insightful. Did you take the picture?
Yes? Good. I'll send it to you. Thank you. Then apparently